Hi, my name is Greg Pollack. I'm a legal assistant with Tapia-Ruano Gunn, and I'm here to ask a few frequently asked questions regarding the executive action announcements by President Barack Obama on November 20th, 2014. And here are the attorneys.
My name is Kelli Fennell. I'm an associate attorney.
My name is Tristan Gunn. I'm an associate attorney as well.
My name is Carlina Tapia-Ruano, and I'm the principal attorney at the firm.
Okay, let's just jump right into it. Tristan, what are the benefits that President Obama announced on November 20th, 2014?
There are many benefits involved in his announcement, but we're going to talk about the two main ones, and those are products of an existing benefit, an existing policy called deferred action. To try and quickly sum up what deferred action is, it's a benefit that's been existing for quite some time, but recently came into light in June of 2012. In June 2012, President Barack Obama announced that he's going to provide an option for individuals who arrived in the United States at a certain time and were of a certain age. So individuals who arrived in the United States before they turned 16 years old, had been here since at least 2007, had not yet turned 31 years old on June 15, 2012, and also fit other certain criteria, were eligible to file for a work permission, a work employment authorization, and were also eligible for the status or situation of deferred action. It was a protection. They could not be deported. And they were eligible, and that protection extended for about 2 years, along with the employment authorization. And that brought a litany of benefits depending on what state you lived in. Now, the most recent announcement piggybacks off that policy in two parts. The first part is the initial DACA process or policy had an age cap. Now, if you'll remember, I said you couldn't be over the age of 31 on June 15, 2012. If you were, you weren't going to be eligible for this benefit. You aged out. This new announcement, or this change in the existing policy, removes that age cap. So you could be over the age of 31, you could be over the age of 41, you could be over the age of 51. Those other criteria are still there. You need to have arrived in the United States before you turn 16. But another change is you don't need to have been in the United States continuous residence since 2007 anymore. What is necessary is to show that you've been in the United States since at least 2010. The other change affects parents of U.S. citizens and legal permanent residents. So the same benefit, which involves protection from deportation and the opportunity, not guarantee, opportunity to apply for employment authorization, is extended to parents of U.S. citizens and legal permanent residents. And what else is necessary? That they have been in the United States since at least 2010, January 1st, 2010.
Okay. And Kelli, when can people begin filing for this benefit?
The answer to that question is there is no exact date, and there's also not a mechanism in place right now. People can't go run out and file tomorrow either. Immigration and the government have told people that the application for the extended version of deferred action for childhood arrivals will be available within 90 days. The other benefit for parents of U.S. citizens or permanent residents is supposed to be available and ready to file within 6 months of November 20th, 2014.
And Carlina, what is your response to those who say that executive action will take away from American jobs?
Well, that's probably one of the most controversial comments or controversial perceptions of individuals who oppose the President's executive action announcement of November 2014. The thought that individuals, recent immigrants, take away jobs from Americans. But I would say that's an incorrect assumption. First of all, the individuals who qualify for these benefits have already been here for years. Otherwise, they don't qualify. They have to have been here for at least 5 years. Those individuals are likely already employed, and now what we seek to have is have them obtain legal permission to work so that they are able to file tax returns and the society as a whole benefits from those employments. And if that argument isn't acceptable, then I would point to 2009 studies that have been done with regards to unemployment and populations of recent immigrants. And it has been established since 2009 that in metropolitan areas and in rural communities where you have high unemployment, you have a very low percentage of immigrants residing in those populations. And the converse is true. In other areas, such as large metropolitan areas in Chicago, where you have lower unemployment, you have higher percentages of recent immigrants living and working here. So a deduction could be made that, unlike what most people believe, that recent immigrants contribute to unemployment, it's the other way around. Actually, immigrants contribute to a lower unemployment in communities, and is not a reason to oppose the executive action.
That's a great point. And Tristan, are individuals applying for deferred action eligible for the Affordable Health Care Act, more commonly called Obamacare?
For the most part, no. If you apply for deferred action, assuming you are approved for your employment authorization, you will get a Social Security number. But unlike U.S. citizens or other individuals, who have legal status in the United States, that Social Security number isn't going to help those individuals obtain things like retirement benefits. It's not going to help them with their insurance subsidiaries.
And Kelly, what happens after 3 years? Will those who applied for this benefit lose their work permits?
That's a good question, and the answer is honestly, we don't know. It's possible that this program could be extended just like the deferred action for childhood arrivals was. We have the second wave of those. We have the second wave of those applications or the renewals going on right now, but it really depends on the government and where the government's at in 3 years, because the government ultimately decides whether or not they're renewing this program.
Okay. And Tristan, will individuals who are currently in deportation proceedings be eligible to file for deferred action?
The short answer to that is yes, they will be eligible. They obviously have to take certain steps. They would be wise, I think, to consult with an attorney. These steps are important. They can be complicated. They are available. Yes, they can. They should speak with an attorney to do so.
And Carlina, what about individuals who have already been ordered removed by an immigration judge?
Well, the existing program of deferred action, referred to as DACA, specifically states that individuals who have final orders of removal are still eligible to apply for these benefits. So we have no reason to believe that the new extension of this program, which increases the population that's eligible, would be any different. And the same can be said with regards to the deferred action benefits intended for parents of U.S. citizen or permanent resident children. Nevertheless, this executive action also indicated that individuals who have final orders of removal after January 2014 are considered priority removal immigrants. So I would caution anyone who has a final order of removal who intends to apply for the deferred action program, final order removal after January 2014, not only to consult, but to hire an immigration attorney to represent them, to protect them in the event that there are any negative consequences.
All right. And Kelly, what if an individual entered prior to January 2010 with permission? Are they still eligible?
Quite possibly. What the government's really looking for here is the legal status of the individual applying on November 20th, 2014. Whether or not they entered with or without permission is not one of the things we're looking at to figure out who qualifies for this benefit.
All right. And Carlina, would a father who had a child out of wedlock still be able to apply for deferred action?
Well, since this new program allows parents of U.S. citizens and permanent resident children to be able to apply for deferred action, the understanding would in most cases be, yes, if you qualify as a father, then and you will be able to apply. The question really remains whether the new program will take into consideration the existing rules, regulations, statutes, case law that have defined fathers of children born out of wedlock to still be a father of that child. But at this point, with the information we have available, I would say yes. If that father can prove they qualify under the existing statute as a father of a child out of wedlock, they will certainly qualify as a father for purposes of this new deferred action program.
And Kelly, what about those who have children covered under deferred action for childhood arrivals?
This entire new benefit is specifically for parents of U.S. citizens and lawful permanent residents. So if you have a U.S. citizen or lawful permanent resident child, you might qualify. However, just because your child has deferred action for childhood arrivals does not mean you will qualify, no.
Okay. And Tristan, can people who have never filed taxes still apply for this benefit?
Yes, they can still apply. Like any other eligibility requirement, that alone won't determine their eligibility. The other factors involved with their case need to be looked at. But again, the short answer is, have you never paid taxes? Are you still eligible, or should you talk to an attorney about your eligibility? Yes, you should.
And Kelly, what happens if someone has an application pending with immigration? Can they also file for this benefit?
Of course, with the current system, the way it is, anyone can file for any benefit that they're eligible for with immigration.
Carlina, is an attorney required to file for this benefit?
No, you don't require an attorney to file for this benefit, but like in any case where you are filing an application for a benefit with the federal government, this is an important application that will determine your future and will determine your legal status in the country. So I would say it is crucial. In fact, without exception, I would recommend that individuals consult with an attorney before filing the application to make sure that not only it's done properly, but filing the application will not prejudice them for any future benefits.
Okay, it appears that's all the questions we have. Thank you very much for your time, and please call our office to schedule a free consultation.